Okay, so yesterday we discussed these different types of research, right? Or legal research, we can say that we had. Now, another topic is there, which is nothing but objectives of legal research. Okay, so now, like, as I told you, research is applicable in every single field that you talk about, and there will be some objectives. We will simply not take a topic, do research, but there will be some objective behind it, why we are doing that research. So what are the objectives of legal research? When we talk about research in the legal field, what may be the main reasons why people take up a research, or how it may help a person, the researcher, how it may help the researcher. So that is what we need to understand here. So legal research, it's nothing but that branch of knowledge which deals with maybe principles of law and legal institutions. It is the study of relationship between world of law and the world that law purports to govern. It is what law is all about. What are the different legislations that we have? Not just in India, but in India, in other countries, what all laws do we have? How are laws in India different from that of other countries? That sort of research also might be there. Apart from that, we also want to know the world, right? Like, is it India? Is it one certain specific state? Is it a certain specific district where the law applies? That also we may try to study with the help of legal research. It is nothing but a systematic investigation of problems and matters concerned with law. Most of the times, like yesterday we discussed Law Commission of India. They are trying to find out, or they are trying to rather investigate on some problems that we are facing. Maybe acid attack is growing like anything, and we were not having a specific law relating to it. It was not considered as a separate crime. Like acid attack in itself was not a crime until few years back. So Law Commission of India realized the matter, they took up a study and they completed the study. That means investigation of problems. They wanted to find out what all are the problems that we have. Why is it that acid attack is increasing so much? It's because punishment is less. It is not even considered as a separate crime under IPC. It simply falls under the classification of causing hurt. Right? So accordingly, Law Commission of India did some research. And after a few years only, changes were made in IPC, and now it is considered as a separate crime. And punishment also is mentioned under IPC. Okay, so this is nothing but systematic investigation of problems. We want to find out what all are the problems that a certain legislation is having, or a certain area of law is having. Okay, so if you look at Indian Penal Code, there you may see. Okay, so these are different types of crimes that are being mentioned, and these have gone through so many different changes, right? All these additions that we see, these are nothing but changes. By way of amendment, these provisions were added. So these additions or amendments came only because we came to know that there are some things which are missing in IPC, and we need to make those changes by way of legal reform, by way of amendments and all that stuff. So it is systematic investigation of problems and matters concerned with law, such as codes, acts, constitution, etc., is legal research. Sometimes you may also take up a study on whether constitution can be amended or not. What is the history of amendment of constitution? That in itself is such a big topic. It's just one section, like one article that we have under Constitution, Article 368. that provides for amendment of constitution. When you look at it from the outside, it's very simple. One provision is there. It's already mentioned in constitution very properly, but then it has such a long history of different cases. So there again, we may have, we may take up a legal research. So it may be relating to some codes, acts, or constitution as well. So what is the difference between these three terms? What do you feel? Codes, acts, and statute.
And I think I don't know about the codes. I can say acts. We can say, I think when some bill is, I think.
Yeah, you are right.
When some bill is accepted by the president, it becomes.
Sorry, when the bill becomes
signed by the president, it becomes act.
Yes. Correct. German, I think you were saying something.
Yeah, acts are the same like the statutes. Acts means the same statutes, right? And codes are like criminal code or CPC, like that, some CRPC, that are the codes. And constitution is the primary material, like that is the supreme of all the laws.
Yes. So constitution is like the supreme of all the laws. After that, we have different legislations, acts, statutes, all that we have. And these procedural laws are usually named as codes, that code of civil procedure, code of criminal procedure, because it is like a collection of the all rules, regulations that will be followed in a civil process or in a criminal proceeding. So it is named as code. So yes, so it may be that we want to matters concerned with a law. We want to figure out what are the problems in maybe Indian Penal Code. Okay, so we want to find out what are the problems with that legislation also. So that can also be a research. It can be related to a legal doctrine also, institutions, legal philosophy, or comparative study of law. As such, no restriction. Researcher is free to take up any topic. It may be one like a theory we have, right? Like some doctrines we have. Maybe the we can say the different doctrines are there, right? Like polluter pays principle. We have something called as polluter pays principle, which is applicable in environmental law. That means whoever is polluting the environment, that person will pay to, make it good. Okay, to make the situation, like restore the situation. All right, so that is nothing but polluter pays principle. So on that doctrine also we can take up a research. It may be on some institutions. How is it that National Green Tribunal is functioning? How is it that maybe Income Tax Appellate Tribunal is functioning? It may be on legal philosophy, whether the concept of justice, equity, and good conscience should prevail or not. That is completely a philosophical study. Is it helping or is it creating confusion amongst people? That also can be one study. Or it may be comparative study of law, where we are trying to compare a certain provision that applies in India. Maybe similar provision is there in another country. We are just comparing it. Or maybe we are comparing, take for example, Consumer Protection Act, the previous legislation, we are comparing it with 2019 legislation. How is it different? To what extent is it different? That also might be a study that we can take up.
Ma'am,
yeah.
Ma'am, what does this doctrine means? I read many places, but I don't know the meaning.
Doctrine as such, it is like a like something that applies like a principle. You don't have torts as of now, right?
I have.
You have. Okay, see,
Yeah.
for law, right, different subjects when you are studying, you will get some doctrines. These are nothing but like a, you can say like a theory, okay, which applies in law. I can give you one example, 1 second. See, like the doctrine of basic structure. Doctrine is nothing but similar to what we say as theory. Okay, like in maths, what happens? There is a theory, right? That how you will solve this kind of a problem, there is a theory for that. Same theory you need to apply in similar given situation, right? Similarly, in law also, there are some doctrines or there are some like theories, okay, which will apply in similar sort of situations. Like I can give you the example of the doctrine of basic structure, which is like the most like famous doctrine for Constitution of India. What is it? What is basic structure? Can you guess it from the name? Or have you
Basic
heard this one?
Constitution, I think Keshwananda Bharti case.
Yes, Keshwananda Bharti case, right. So what is that?
I think the basic structure like sovereign, secular, I think this is no.
Yes. So what about that? Like we know what is basic structure, but what after knowing what is it all about?
Like means, ma'am, can you repeat?
Like where is this doctrine applicable basically?
Don't know.
It is applicable in case of amendments. That is why I said, right, amendment is having like a very big history. Lot of confusion, lot of like conflict between judiciary and executive. After that, judiciary came up with this doctrine of basic structure in Keshwananda Bharti case to settle down all these conflicts that were going on. All right, so this is a very important doctrine. This is like a theory. It mainly says, yes, Parliament is given the power to change the constitution. So Parliament can change any and every part of constitution. Whatever you want to do, you are free to do it. But that does not mean you will change the basic structure of the constitution itself. Okay, so basic structure of the constitution as in certain very basic things like you said sovereignty, providing for fundamental rights might be, then supremacy of constitution. Like that, there are list of things which are considered as basic structure of constitution. But then this list is not like exhaustive. It says list is open. Today we feel that these are basic structures. Tomorrow if somebody else wants to add anything, they can add it. Again, like additions can happen. All right, so this is nothing but a doctrine that Parliament is free to make any changes, but they cannot change the basic structure of constitution. That means it's like a theory. Every time Parliament wants to make a change, they need to apply this theory. They need to see, are we changing the basic structure or is it fine? Okay, same way, doctrine of harmonious construction. What is harmonious construction? It might happen that there is one legislation. In a legislation, there will be multiple sections, right? Sometimes it may happen one section is saying something, another section is saying something completely opposite. Which one do you follow? It's one legislation at the end of the day. Which one do you follow? Their judiciary will try to harmoniously construct these two principles, harmoniously balance these two principles so that both of these, like will prevail, and in a sort of diplomatic way, they will try to like balance it out. Those are nothing but doctrines, or you can say theories or principles which apply, and there are multiple such doctrines in law. In different subject you will see that. Okay.
Okay.
And these, like for different subjects, you will get different types of doctrines. Okay, you can simply remember nothing but like a theory only. It will apply in similar given situation. So it may be that you want to, that it is related to a legal doctrine. You want to study how concept of basic structure was developed, and once it was developed in Keshavananda Bharati, after that in which all decisions, new additions were made in this list of basic structures. That can be a research. All right, so legal philosophy, comparative study and all that stuff. Now, objectives of legal research. What are the main objectives? What might be the main purposes for which people take up legal research? First of all, find out the lacuna. We know, right, that law is not static. Law will change with time so that it can address needs of the present day situation. So legal research will try to find out what all problems are there in this existing situation, in this existing legislation that we have. If you take the example of Consumer Protection Act, in the year 2019, Consumer Protection Act, like a lot of changes were made to this legislation. Previous act was repealed, a new legislation came into force, Consumer Protection Act 2019. Why? Because they identified that there were so many things which were missing in the previous legislation. These days, people are buying goods online. Like most of the people, most of their goods, they will purchase it online. Most of the services, people will take online. So in such cases, they were not covered under the previous Consumer Protection Act. So new legislation says, even in case of electronic transaction, online transaction, that also will be included. They increase the jurisdiction of all these different forums. Certain other bodies were established. That means legal research will try to find out what all problems are there in an existing law or in an existing process, and they will try to address that. It plays a vital role in bringing amendments in existing legislations. When we already have a legislation in place, it really helps us to understand what all things are missing there. And based on that, we can make the necessary changes as well. Okay, so this is the first one that we try. Yeah.
Lacuna means lack, no?
Yeah, whatever is lacking in the legislation. In existing one, whatever is lacking, we want to address it. Like if e-commerce thing was missing, we want to add that. If something else was missing, we want to add that, so that it serves its purpose.
Like, find out the gaps. Gaps means like gaps.
Yeah, find out the gaps and try to address.
I can use that word. I can, instead of this word, I can use like find out gaps in the existing legal system.
Yeah, find out the gaps, address the gaps, whatever way you want to, right?
Excuse me, ma'am.
Yeah.
Ma'am, can you wait for just 1 minute?
Yeah, sure. Sure. Yeah.
This news is coming now.
This? Yeah.
Now that picture came, this is the topic now in Kerala. It is.
Oh, is it?
Recently happened opposite actually. The lady tried to put acid on the man's face.
Oh. Husband and wife, or what was it?
It was some love relation, and she put acid, but he herself also got injured.
Oh. That is actually very less, but yeah, it is there where men is targeted.
2013.
Yes, 2013 amendment.
Yeah, ma'am, please continue.
Yeah.
Thank you for.
Yeah. Yeah, so see, we have one provision under IPC, which is nothing but voluntarily causing grievous hurt, voluntarily causing hurt. Okay, so previously acid attack was included under that, it is nothing but like causing hurt or grievous hurt to a person. But then it was realized that no, like we should have at least one, like IPC is such a, like such a lengthy legislation. It is having 511 sections altogether. See, 511 sections altogether, defining different types of crimes that may be committed in India. And acid attack is such a, like serious crime, which is becoming like, it is committed very often. So we should be having a provision relating to that. And that's the reason why in 2013, right, by way of this Amendment Act, Criminal Law Amendment Act 2013, it was inserted by way of this two sections, 326A, 326B. This means nothing but they figured out that it is a problem that we have. Even like people are not much aware about it because we don't have this provision. So we need to insert this as a provision. Then some obligations were given to different government bodies are there, right? They may be given obligation that you even generate awareness amongst people relating to these matters and all those things. This is nothing but trying to fill this gap or the problems, trying to address the problems which is there in an existing legislation. That IPC is not enough in dealing with this, so we need to make some changes in IPC. Same thing happened with that Nirbhaya gang rape case of Delhi, right? After the incident happened, it was realized that IPC is lacking in a lot of different provisions, and so many changes were made after that. All right, after that, so many different changes were made. Plus, one major change was relating to Juvenile Justice Act. Are you aware what that change is all about?
For what?
Juvenile Justice Act, are you aware?
No, I just heard like, I think it's, no, I don't know. No, ma'am, I don't know about.
You don't know? Okay. So are you aware that like the main culprit was a juvenile there in that case?
No.
You are not aware? How come? It was everywhere on news, right? He's working in some dhaba right now, all that stuff everywhere on news. So this legislation is there, which is Juvenile Justice, Care and Protection of Children Act 2015. Okay, before that, I'll tell you one thing, okay? Otherwise, what happens? IPC is there, which is defining different type of crimes. That means if we are committing any crime, we will have to face the consequences. We will have to face the punishment that is provided. And for every single offense, IPC has mentioned punishment as well. Okay, like if you look at any provision, take for example, theft. Punishment is also given that it may be up to 3 years of imprisonment or fine, or it may be some imprisonment plus fine. That means if we are committing a crime, we will have to face the consequences as well. We will have to face the punishment also. But in IPC, there is one provision called as general exceptions, which means fine, you may have committed a crime, but it may be an exception. Okay, it is not a normal situation. It was an exceptional situation wherein you committed the crime. And for exceptional situations, you can escape the liability completely or to some extent. Okay, so in those, have you heard before this one, general exceptions?
Yes, ma'am.
So in those, one very important provision that we have is relating to child. Okay, and IPC says any child below the age of 7 years, they are mentally not that much mature to understand or to differentiate between right and wrong. Okay, so they cannot be held liable for any crime. Act of child under 7 years of age. It says nothing is an offense which is done by a child under 7 years of age, because they do not have that mental ability to differentiate between right and wrong. Okay, similarly, there are other provisions, like what will happen if a child between 7 to 14, where is it? Yeah, 7 to 12 years commits a crime. What will happen if a child between 12 to 18 years commits a crime? Like that, we have all the provisions in law. Previously, what happened, right? Juvenile Justice Care and Protection Act, it said if any child below the age of like 18 years, okay, within 18 years range, if someone has committed a crime, they cannot be tried like a normal adult person. They will not be given the punishment mentioned under IPC, but rather they will be tried under Juvenile Justice Board, which is like a lot more softer version of trial, where they will be sent in some rehabilitation center for maybe up to 3 years. They will be given all the facilities, vocational training and everything. Mainly because the person is a child, right? He has his entire life in front of him. So they do not want to send him to regular prison where he might mingle with other criminals. They want to send him to a rehab center so that the child can reform himself. That was the provision. But after Nirbhaya gang rape case, this matter was raised that most of the crimes where juveniles are there, they are within the age group of 16 to 18 years. Might be after 2 months, their 18th birthday was coming. Just because of that 2 months gap, they would escape this entire punishment completely. And 16 to 18 years, they are like already mature enough, right? They are not kids anymore. So they said that IPC is having like false in that part, and also this Juvenile Justice Act. So they made changes here. They said that if a child within the age group of 16 to 18 years commits a crime, we will straight away not try him under Juvenile Justice Act, but rather court will try to understand if that child was mature enough or not. If court figures out that, okay, he was mature, court will try him like a normal adult under IPC. If not, he will get the protection of Juvenile Justice Act. That was again nothing but addressing the problems which like existed previously. Okay, so this was like a major change, and this is a very good example that even you can write in your exams also. Juvenile Justice Act, if it's fine if even if you do not remember this part, Juvenile Justice Act, you can simply mention, okay? So we want to find out the problems. We want to address it as well. Next is discovery of new facts. With legal research, it may be beneficial in bringing laws. Okay, the fact that acid attacks should be categorized as a separate crime under IPC was also highlighted by legal research by Law Commission of India. That means it is discovery of new facts. Already relating to acid attack, we were not having any such provisions, but a new fact was addressed, right? Law Commission of India put that thing in front of the government, that you need to make this as a separate crime so that people will realize its seriousness, and also greater punishment can be given. This is nothing but discovery of new facts. Consequences of new laws or judicial decision. This is a very common thing that you will see. Like if you like on YouTube or somewhere, if you search sometimes latest judgments, latest court decisions like that, you will see judicial, right? Latest judicial decisions are like a major topic. Okay, even if someone is appearing for exams like CLAT, not judiciary as such, yeah, CLAT and all, there also questions will be there based on latest or latest judicial decisions. Okay, so when we are studying a latest judicial decision, a decision that was given by court, might be few months back, in such a case, we try to understand its consequences as well. Okay, so because court said like this, what will happen? What will be the consequences? That also may be a legal research that people will do. Or is it clear, judicial decision part?
Yes, ma'am.
Or consequences of new laws. If a new law is introduced, what might be the consequences? Like you must have seen this farm bills that were in place, right?
Yes,
all the protests going on and everything. And at that point in time, everywhere you will see the consequences. What will happen if those farm bills were made applicable? Okay, so what will happen in that case? That is nothing but consequences of new law. What will happen if those new provisions were applicable? What will happen if that minimum support price was not given to farmers? All of those things were figured out by way of legal research again, right? So what is the present status of those farm acts?
I think the whole 3 farm bills were repealed by the government.
Was it already repealed?
No, I think they are repealed in this like winter session. No?
Yeah, in this session they have promised, right? They will, yeah, right. So this is again nothing but legal research, like whatever was going on in all those previous days, that is nothing but consequences of a new law. What will happen if this new law applies? Same way, relating to judicial decision also, same thing will happen. Okay, judicial decision, any latest decision you can think of? Maybe that, I guess one consumer protection.
Ma'am, can we say demonetization?
Monetization, it's not.
Yeah, GST.
It's, you know, like monetization, demonetization was again like a, you know, like a decision of government, not like a judicial decision as such. It was an executive decision, right? Judicial decision as in court that has taken a decision. Like you can say here, you can take the example of GST, but yeah, judicial decision as in, I guess one day I told you that example of consumer court giving 2 crores compensation. Do you remember that? That haircut example?
I don't know. I don't remember that.
You don't remember? I think I told you if I'm not wrong. So basically one model was there, she went somewhere for a haircut and hair treatment, but it was not done properly. She was not happy with services, so she filed a case in consumer court and she was given 2 crores compensation. So that may be that someone can do a research on that judicial decision. What might be the impact of that decision? Is it that service providers will be more careful that they are providing quality services? And is it also that consumers will be more open in approaching the consumer forums because they like somehow they would feel that, okay, fine, like these bodies are actually doing some work. So is it that their confidence would, like they would have more confidence on these bodies? That might be a legal research that we can do. Okay, judicial decision as in whatever decision court has given, okay, on a certain decision, on a certain judgment, we might be doing a legal research. All right, like I think Manav, in your college, that those cases were discussed, right? Plessy versus Ferguson and all.
Yeah.
That can
Yes.
also be a research on it, right? That by reading those cases, you try to understand the, like history of this racial discrimination in USA. Nothing but you are doing a legal research over there. Okay, so that might be the third point. You are trying to understand what might be the impact of a new law or what might be the impact of a decision that court has given.
This protest which has happened, they were expecting this one when introducing this farmers law, correct?
Yeah, yes.
Protest. So it was the consequences after introducing the new law. This was the consequences. So any researcher can do a research that after implementing this law, this kind of protest can happen. Like
yes.
He can make a he can make a report.
Yeah, he can do that. That this might be the outcome. People might not be able to focus on their cultivation. People might, like farmers might be busy in protesting there. Someone may lose their life, this, that. Everything might be a legal research. Or they may say, what will happen if it is applied? After that, like 2 years, 3 years back, what will happen? That also can be a research. Any area we can take up. Yeah, propound new legal concepts. Legal research may also help to propound new legal concepts. For example, the concept of absolute liability was developed by Honorable Supreme Court after doing necessary research and finding out strict liability principle is not serving the purpose. So what is strict liability?
Strict liability. I don't know the definition, but like I know the meaning.
Yeah, you can tell the meaning. I don't need definition.
No, like it's strict liability is like I think it's like in the case of compensation, we can say, or
yeah, compensation.
like people when pay compensation for the damages in the case of fault or something. Like
which case was it? Do you remember the case?
No, I don't remember the case, I think, but it's a case of I think it's relating to theft or robbery, I guess. I don't remember.
Not theft or robbery. How come? This is a principle from torts, right? Tort is a civil wrong. And theft or dacoity is crime, right? So it cannot be theft or dacoity. Yeah, compensation, you are right on that part. It is relating to compensation.
Yeah, if we talk about like strict liability, can we say selling drugs or alcohol to minors? It will fall under strict liability, I guess.
It's no, for that we have a separate legislation. Okay, usually for these drugs, alcohol, or any like all those like the materials which are harmful, for that we usually have a legislation. Okay, some cigarette act, some act, this act, that act, all the different sort of legislations we have. This is mainly applicable for like
like driving, causing accident, drunken driving, like that.
Not that also. It might be like I am keeping something in my premises for my own benefit, for my own use. It escapes from my premises and causes loss to you. Okay, so the case where this concept was developed was Rellins versus Fletcher. So one person was having like a meal. To run that meal, he needed electricity. For that, he wanted to store water in a very huge quantity. So he stored water and water escaped to his neighbor's premises, and neighbor was also having mines business, so it caused him heavy loss. Neighbor filed a case against him that because water escaped from your premises, caused loss to me, you are strictly liable. Whether you were negligent or not does not matter, you are strictly liable. So court asked, yes, you need to pay compensation because you are strictly liable. But what happened, right? In this principle, certain exceptions were there, like act of God, third person's fault, the person is only guilty. 5 exceptions were there. So in India, Supreme Court realized that these kind of matters where something is escaping, some harmful gas is escaping, these matters are becoming very common. And when we have 5 exceptions, somehow or the other, parties were able to prove one of them, and they will escape the liability. So basically, this principle was not serving any purpose. So because they realized that, they propounded new legal concept. Supreme Court of India developed a new concept altogether. They said, we are applying absolute liability, where person will be absolutely liable, no exceptions. We are not seeing whose fault, who was negligent, nothing. If from your house, water is escaping to your neighbor's house, you will be held liable no matter what. That means it is an entirely new legal concept that was developed. Is it clear?
Yes.
Yes.
So it can relate to any other matters also, where court may say, okay, fine, how to decide compensation for a certain case. Okay, like hit and run case, this case, that case. That formula for calculating compensation might also be a concept that they have developed. Same way it may apply. So this one is a good example that you can remember. From strict liability, they developed absolute liability. Next is analyze law and legal institutions from the point of view of history. As I said, law will keep on changing. So legal research may aim at analyzing a certain law or legal institution from the point of view of history. Such study clearly identifies the entire journey of that legal concept. Like I said, Amendment of Constitution of India. It is one article, 368, but having such a long history with so many landmark cases. So if you do a research on that provision, that okay, fine. Initially, when Constitution of India was adopted, what was Article 368? What was the wording of Article 368? What was written inside that article? After that, what all cases happened? And at present, what is written in Article 368? That means you are studying this entire history of Article 368 from starting till date. That can again be a research which will help you understand the value of this doctrine of basic structure. Okay, like how, like how clever was that decision, Keswananda Bharati. How you will understand it? By studying this history of this entire article. Okay, is it clear?
Yes, ma'am.
Examine the nature and scope of new law. So when a new law is introduced, we can, like this farm laws, right? People did so much of research. What all things are there? What it talks about, what it does not talk about, everything was discussed. That means they are clearly understanding nature and scope of a new law, where and all it applies, whom and all it will be affecting, and all that stuff. Right? That is how farmers came to know that we are the one who will be majorly affected by this legislation, and they came forward to protest against them. How? because of some research done by all the people around. They came to know what will be the impact of this new legislation. Next one is highlighting merits and demerits of legal concept. It may be like a very basic research that maybe students are doing in their like college days, like when this death penalty thing, right? Whether it is good or bad. For that, there may be a research done. Okay, I think when we were in LLB, this Ajmal Kasab, you remember? Taj Hotel terrorist attack.
Yes, ma'am.
Do you remember? Yeah, he was given death penalty. Okay, and that time this topic was like so popular. Okay, and we were 100% confident that for sure there is going to be one question on positives and negatives of death penalty. That was the topic like everywhere, positives and negatives of death penalty, whether it's some essay competition going on, some debating, this, that, everywhere. And we in fact had a question also on positives and negatives of death penalty. That means it also is nothing but like a research only, where you try to understand both the sides of a legal concept. Good sides also, bad sides also. Okay, so this is nothing but another objective that we may have. Next one is develop critical thinking. As a subject of study, legal research in academics aim at developing critical thinking ability among students. Today's students are going to be tomorrow's whether advocates, judges, policymakers, and whatnot. So developing critical thinking ability is very much important. That can also be an objective of legal research, because today you might be studying the goods and bads of a legislation, the outcome of a legislation and all that stuff. Tomorrow, you might actually be drafting a bill yourself. So when you have this critical thinking, you can criticize your own draft and you can make the changes yourself. So this can also be one of the objectives, that it develops critical thinking from the starting point only, so that whatever you are doing in future does not matter, it can be applied like a skill. And lastly, better interpretation of legal rules. So legal research can also play a significant role in better interpretation of existing rules or regulations. What is interpretation?
To conclude something.
To conclude something. Okay. Right. So to conclude something, to derive some meaning out of something, right? So it will also help us to better interpret existing laws, to properly understand some provision. Legal language may sometimes become a little complicated or too technical. So simplification of complex text is also one of the objectives of legal research. Okay, like if a new law is introduced, a layman may not be able to understand it properly. There, a legal research can help them. Okay, a person may study this entire legislation and provide the summary in a very basic layman language so that anyone who wants, they can understand it. Okay, like when these farm bills were introduced, definitely all of us did not download the entire bill and go through the provisions. Rather, what we did, we read some articles here and there, we read some newspapers here and there, or watched some videos. And from there, we got the conclusion that, okay, these things are there in it. But we did not read the entire legislation. Still, we know what is there. That means it helps in better interpretation of legal rules. By doing a legal research, they try to sum up the entire thing. What is it that these farm bills are having? Okay, so this is nothing but again an objective of legal research. Is it clear?
Yes, ma'am.
The point 5 again one more time.
Point 5. Yeah. So analyze law and legal institution from the point of view of history. That means we are not studying something like how it exists today, but how it existed in this entire time frame. Like if you remember, Constitution of India became applicable from 1950. Okay, so in the year 1950 also, Article 368 was there, which talks about amendment of Constitution. Even in 2021, that same article is there, Article 368. But in its wording, it has gone through some changes. Okay, the statement that you would see inside, it has gone through some changes. The heading that you see, it has gone through some changes. And it has not happened overnight. It is a result of a lot of landmark cases that Supreme Court decided. So there you can do a legal research to understand history of Article 368. In the year 1950, how it started, what idea drafters of Constitution had at that point in time. After that, when first case file, second, third, fourth, fifth, basic structure doctrine came, additions were made, all that is nothing but history. So you can do a legal research with the objective of understanding history of a certain provision of law. Okay.
Okay.
Yeah. Other points are clear, right?
Yeah, yes, ma'am.
Yeah. Okay, fine then. So we'll continue with some other topic tomorrow. Okay.